Okay, we are streaming live via YouTube, the preliminary hearing calendar. The next case we have on the calendar is the state of Georgia versus Paul Jerome Grady. Mr. Grady, this is your preliminary hearing for today for the charges pending against you, specifically warrant number 2022 WA18858 for the charge of robbery by force. A second charge of warrant number 2022 WA18859 for the charge of battery. Third charge warrant number 2022 WA18860 for the charge of obstruction of an officer. Those are the four charges pending against you. The state will be represented by ADA Laura Almond, and the defendant, Mr. Grady, is represented by Attorney Rogers. The state ready to proceed forward with the first witness?
We are, Judge.
Okay.
At this time, I'd like to call Officer Christian Sterling. Will you raise your right hand? Do you swear or affirm that the testimony you're going to give in this matter now pending before the court is the truth, the whole truth, and nothing but the truth?
Yes.
All right. If you can place your hand down, state your full name for the record.
Officer Christian Sterling.
And how are you currently employed?
I'm a K-9 officer, Clayton County Police Department.
And were you employed in that capacity on December 10th of 2022?
I was.
And do you have arrest powers?
Yes.
Are you post-certified?
I am.
And on that date, do you have the occasion to come into contact with this defendant, Mr. Grady?
Yes. Yeah, it was a robbery.
Okay. And what was the nature of that contact?
Basically, the call went out as the BP at Riverdale Road and Garden Walk. The complainant, the victim, was the clerk working that night, stated a black man wearing a black jacket with blue on it and black pants, had gone in the store, grabbed several beers, had punched him in the face twice, and left the scene. Myself and the rest of my shift made our way up into the area. I drove across the street to the adjacent apartment complex at 5751 Riverdale Road. As I drove in, I looked to my left on the second row of buildings. I saw a man matching that description. He saw me pull in. He was standing on the corner of the building closest to the wood line. As soon as he saw me, he ran around the corner, drove my patrol car around the corner, jumped out, started chasing him on foot, telling him to stop. We ran through the woods into the next complex, continued running toward the back where he slowed down. As I was coming up to him, he appeared to be extremely intoxicated. He began pulling beers out of his jacket, putting them on the ground, and he was apprehended and taken back to the scene.
Okay. Now let's walk back through the victim's chronologically the events. Okay. So what did the victim advise that the defendant did once he entered the store?
He said he went back to the back coolers where the beer was, and he observed him taking beer out and putting them in his jacket. So he approached him, told him to put it back, and just asked him to leave.
And did the defendant make any verbal responses at that time?
Yeah, I believe he did. He said he wasn't going to leave, and then he punched the clerk multiple times in the face, leaving visible injuries.
Okay. And now let me ask you this. When he struck the clerk in the face with his fist, was he still in possession of the beer?
Right.
Okay. Now, did you observe any visible injuries to the victim in this case, Naeem Shanik?
Yes.
What were the nature of those injuries?
He had some swelling around his eyes, and his lip was bleeding, and his glasses were broken from being punched.
Okay. And I want to back up just a little bit. When he fled on foot from the incident location, were you wearing any sort of a uniform that would identify you as a police officer?
Yes, I was.
And did you identify yourself to him as a police officer?
I did.
Okay. And you were in fact on duty at that time, correct?
Right.
And all this did occur here in Clayton County, is that correct?
Yes.
Oh, no further questions at this time, Judge.
Okay, Attorney Rogers, your witness.
Thank you. Officer, I guess I'll start kind of at the end of those questions there. And I want to get a little bit of clarity about when you first see who you believe to be, I guess, the reported person. Where are you when that person takes flight, according to you? Like, are you still in your vehicle? Are you on foot? Where are you at?
No, I'm still in the vehicle.
Had you said anything to them before they left the area?
No.
So, again, I just want to make sure I'm understanding. So once that person starts to leave the area is when you get out of your car, is that correct?
Right. It wasn't like, oh, I'm just going to walk around the corner. It's, oh, a police car is driving down, at which point he stops and then runs around the corner and immediately starts running upon sight of law enforcement. And he's matching the description of the person that just robbed the store across the street.
Okay, and I don't know if maybe you might have missed the question. So again, my question was, before the person starts to leave the area, you're not out of your vehicle, is that correct?
Correct.
And you haven't said anything to that person, correct?
No.
And the first time you get out of your vehicle is after that person starts to leave the area, correct?
Correct.
And I will start kind of back at the top. Are you the lead officer on this case?
Not initially, but I ended up taking over the case.
Okay. What do you mean when you say not initially?
I wasn't initially dispatched to the call. I put myself en route to it. Originally, I was just looking for the suspect.
And so at the time that you're looking, are you the person that had the conversation that took the initial description and everything?
No.
So the description you're hearing is just whatever has come out on the radio?
That's other officers who are with the complainant / victim.
Right. What I'm saying is, you're not on scene while the description is being given. You're just hearing what's being relayed over the radio.
Actively searching the area.
And to your knowledge, are there any witnesses to the incident?
Not to my knowledge, but I do believe the video footage was provided.
And we say that you believe that it was provided. What's the basis for that belief?
The manager had to be there for the footage to be given to us right then, but the following day during day shift, the manager stated he was going to burn it onto a CD or a USB drive to be picked up.
Who did you say said they were going to do that?
The manager.
Have you seen any video?
I have not, no.
And as you understand it, when I'm not sure exactly what his name is, the clerk that's reporting it, as you understand it, when he makes contact with let me back up. Have you ever spoken to the clerk personally? Have you ever spoken to him?
I did, yeah. After he was placed in custody, I drove back over there to the incident location.
Okay. And did you discuss what is alleged?
Yes.
And so at the point that the clerk first makes contact with Mr. Grady, like says anything to him or whatever the case may be, what is the first contact? Did he say something, touch him? What's the first contact?
He said he saw him taking the beer out of the cooler, put him in his jacket, counter back to the cooler, and told him to put it up and leave. He didn't tell him that he was going to call the police or anything. He just wanted him to leave.
Hang on one second, because I don't know if it was just on my end. There were parts of it I couldn't quite catch what you said. You said, sounded like someone was moving or something like that. You said the clerk, and that's when it kind of started getting a little bit.
He said that the clerk, he went around the counter because he saw the offender taking the beer out of the refrigerator and putting them in his jacket. So he observed this. So he walks around the counter to the cooler and approaches him and tells him to put the beer back and leave the store.
And that's when the punches are allegedly thrown.
Right. I believe what the clerk said was the offender said F you and punched him repeatedly in the face before fleeing the gas station.
Do you know if any more beers are taken after the punching?
He had 2 on him when I found him.
Yeah, and I want to make sure being clear about my,
1 minute.
yeah, it sounds like we got somebody else in.
Okay.
I just want to make sure I was being clear about my question though. As you understand it, and correct me if I'm wrong, there's the alleged taking, the clerk goes to confront Mr. Grady, the scuffle happens. Are any beers taken after the scuffle, or are all the beers are already taken before the clerk even arrives?
From my understanding, the beers that he observed him put in his jacket are the ones that were taken.
No further questions at this time.
Okay, ADA Almond, any redirect?
Yes, Judge. Yes, Judge, just briefly. I just want to clarify, when you see this defendant running from the scene of this incident, and you're in your vehicle, when you get out of your vehicle, do you give him verbal commands to stop?
Right, I did. I had to catch up because he had a little bit of time on me. I was probably, I don't know, maybe 50 yards away from the first point that I saw him walking in front of the buildings to him seeing me, to me having to drive over to where the pavement ended to where I had to jump out. And basically we followed the wood line down. There's a known cut right there that connects both the complexes, and he was already running through the cut when I got there. So I had to catch up to him at 5801 Riverdale Road.
Okay, now, and were you able to clearly observe what he's wearing?
Yes.
And did he in fact match the description of what you were given as the person who had taken the beer from the store?
He did.
Okay, and did all of this occur here in Clayton County?
It did.
All right, no further questions, Judge. Just argument.
Okay. I do have one question for the officer. Were you able to ID the suspect at that time?
Yes, ma'am.
Okay, and can you identify him today?
Yes, ma'am. He's wearing an orange jumpsuit.
Okay, at the Clayton County Jail?
Yes, ma'am.
Okay, thank you. Okay, ready for argument for the state. Defense, do you have any witnesses?
Well, yeah, I did actually a couple of questions, I guess, in relation to your question. And,
Okay, sure. Go ahead.
just when you said at that time, when the judge was asked you about at that time, what were you referring to? Say yes. What time did you mean?
I'm not understanding your question.
When judges asked you about were you able to identify him at that time, what were you referring to when you said yes that you could identify him at that time? What did you mean?
The clothing description.
Okay. And after the apprehension was made, is there an identification ever made by the clerk?
Yes.
And everything that we talked about, as far as the first approach that you made when you saw, when you say you saw Mr. Grady the first time, the conversations with the clerk, all of those things, are they all on your body cam?
Yes.
No further questions.
Okay. Do you have any witnesses, Attorney Rogers?
No, ma'am.
Okay, ready for argument. ADA Almond,
Yes, Judge, we'll waive opening and close.
Attorney Rogers.
Yeah, just the argument, I would say that my first, I guess, issue with the charge would be probably that I think that it should be more of a theft by taking and a battery. The beers, I guess, what prompted the response from the clerk, as I understand it, was the fact that the beers had already been taken. At the point that the clerk comes and makes contact with Mr. Grady, whatever, you can't unsteal something. If you've already taken it with the intent to take it from the owner, it's taken at that point. You can't unsteal it. So the fact that the theft has already occurred, the taking has already occurred before there's any sort of contact or anything between the two of them, there's not a robbery at that point. There is a battery alleged in affecting the getaway, so to speak, but the property was not taken off of off of the complainant's person. It sounds like he was at a distance. He had to walk around the counter and go back to the cooler where he was at. So he certainly tried to stop a theft, but the fact that someone tries to stop a theft doesn't transform it into a robbery. So for those reasons, I would ask that the robbery be reduced to a theft by taking. And other than that, Sean, I would submit on the evidence.
Okay, thank you. ADA Almond.
Yes, Judge. The state would ask that all charges be bound over as is. I would like to point the court and defense counsel to a case. It's 199 Georgia App 750. This is a 1991 case, a Georgia Court of Appeals case, and it literally deals with the exact same scenario. While it's true that the use of force has to occur contemporaneously with the taking of the property, otherwise it'd be rendered a theft by taking. What this court says is that the store owner was not divested of legal ownership of the property until the physical force was used against the cashier to relinquish the possession of the beer to him, and the defendant was then able to leave the store. So if I could just briefly, the facts of this case, the defendant Dutton was charged with robbery by force, and the facts allege essentially that he had entered a convenience store, went to the back where the beer cooler is, took 2 packs of beer, and while they were in his possession, the cashier moved from behind the counter back to the beer cooler, confronted this defendant Dutton, asked him to put the beer back, and at that point, the defendant did refuse and then essentially knock the cashier aside and then run out of the store with the beer. The defendant appealed in that case, saying that there was insufficient evidence to charge him with robbery by force, because essentially what defense counsel Rogers is saying is that the taking was completed before the force was actually ever used against the clerk. But the court disagreed with that, and in fact upheld the defendant's conviction and said that there was evidence that the beer was taken by force, and that was regardless of the fact that defendant Dutton took physical custody of the beer without using force, because he did not in fact divest the store of legal possession until, by using physical force against the cashier, he compelled him to relinquish possession of the beer to him, essentially by striking him as he's running out of the store. So I mean, it's literally the exact same fact pattern that we have in this case, where our defendant has taken possession of the beer. The clerk walks from behind the counter to the back, tells him, no, you need to put the beer back, you need to leave the store. The defendant refuses and uses some choice language. And at that point, while still retaining possession of the beer, then strikes the clerk, causing visible injury, and subsequently leaves the store. He was not striking. And so the way the court looks at it is that the use of the striking is sufficient to establish the element of force for robbery by force, because again, the legal possession of the beer, although he is in physical possession of it at the time, he's not divesting the store of legal possession of that beer until he in fact hits the clerk. So the clerk is then unable to regain any possession of those items and then subsequently leave the store.
Okay.
And I don't know if ever in my legal career I found a case that it's so on point. So
very rare, I would say that. Based upon the evidence presented to the court today, I do find sufficient probable cause to bind over all 3 charges against defendant Grady to Superior Court of Clayton County, specifically the charge of robbery by force, as well as the battery and obstruction of a law enforcement officer. That is the order of the court today. That will conclude your hearing, Mr. Grady. And I want to thank your counsel for their presentation of the case. Thank you.
Thank you, Judge. And I actually need to appear in another courtroom, so may I be excused?
Okay, you don't have any other cases on the calendar for today?
No, Judge. Unfortunately, I'm gonna have to defer to
Okay.
ADA Hansinger, but I've only got one case at 1 and then one case at 3. So I'm gonna jump back on. So
Okay.
I'll be back. It'll just be temporary.
Okay, hopefully we won't be here. I'm just kidding.
Fingers crossed. Thank you, Judge.
Okay. Thank you.